Hello, Michael. It's Tracy Jackson here. This is assessment 2, and we are acting for Patricia against Alfredo in relation to their lease negotiations. I think where I would start with this, and where I generally like to start, is to map out a little diagram of who wants what. Sometimes we might not know. I mean, in this case, we know what Alfredo wants on the instructions, but sometimes we don't, and I would still try and guess, make an educated guess as to what he wants, so that it could drive the parameters of where we're coming from, and so we can start to think about what we could offer to offset what he wants. I'd probably then call Alfredo's solicitor first before starting to write expensive letters. I'd sound them out a little bit, see if they're one of those rare precious jewels who are reasonable, and have a chat to them first about whether the possibility of negotiation is there at all, and then if so, what the parameters might be, and get an idea, a feel for where we can move and what's important. So I think at first we know that Alfredo wants Patricia out. He wants outstanding rent of $30,000 plus interest. He wants reimbursement for the damage to the unit and compensation for loss on a reletting. Patricia wants a continuation of a lease. And she wants an incentive payment of $35,000 that was promised to her by Giuseppe. And she wants compensation for disruption to her business due to Jamil's interference. Now, I guess the main starting point is that the lease is proprietary and valuable in a commercial sense, because that idea of exclusive possession is critical for running Patricia's business. So this is the big value to her. Her ability to continue operating her business from Unit 1 is her paramount concern. Alfredo probably wants what he wants for fairly similar reasons. He wants a tenant without the issues Patricia has. So he wants out so he doesn't have to pay the incentive. And that would be a big thing for him, paying that $35,000 incentive. Whether or not he thinks that he's liable for it, he would be worried about that. So he doesn't have to pay the incentive, and he doesn't have to put up with unpaid rent and damage. So he wants a new tenant in so that he can start earning money on his return. So I guess the starting point is, if we can fix the problems then that he's having with Patricia, then he'll have the economic benefit in keeping Patricia and renegotiating the incentive payment. So as a starting point, Patricia could offer to forego the incentive payment in discharge of the outstanding rent. It's not a totally sweet deal for Alfredo, but it's a good start. She could further offer to undertake the repairs necessary to return the premises to a state of good repair. So that means she's got the rent up to date and the repairs fixed. This would mean Alfredo wouldn't require reimbursement for damage. And with Patricia staying in the unit, he also wouldn't require compensation for loss on a reletting. So all of his wish list is being satisfied. With rent, damage and reletting no longer an issue, Alfredo would probably benefit then from having Patricia remain in the unit rather than go through that downtime in between tenants. There's a downturn in the market in Townsville. He's unlikely to find new tenants quickly, and they're probably unlikely to pay the same rent because they'll be in a really good negotiating position. So while he might believe he can recover from Patricia if he does proceed with a forfeiture of the lease, he might think he can recover the downfall from Patricia, and he can, the loss in rent and the losses in reletting. But that'll, of course, depend on whether she can keep her business and therefore her income flowing. So if she's bankrupt, Alfredo's left with no tenant, no compensation, and repairs to fund. Patricia could offer to forego compensation for disruption to her business if Alfredo undertakes to address the issues of concern in relation to Jamil's heat play business. It's crucial to Patricia that the interference from Jamil comes to an end so that she can get about building her business without the nuisance. And that would end up with the outcome that Patricia ends up staying at her premises without the interruption to her business that would occur if she was required to relocate. She'd also continue without fear of further disruption due to Jamil's neighbouring business. So her outstanding rent would be discharged and she could continue with the lease after fixing the repairs. Alfredo does not then need to be inconvenienced and incur the expenses associated with reletting, no longer need to be concerned about the damage to Patricia's shop premises. And by allowing Patricia to continue with her lease, he has the benefit of a tenant known and proven to him, better the devil you know kind of thing, providing him with some security. He's able to discharge the $35,000 owed under the covenant without finding the funds to make that payment or having to litigate the issue in court. And this figure represents probably around about an extra $5,000 on top of the rent owed, which will most likely even out with respect to the interest that he is owed on the outstanding rent. If Patricia wanted to enforce the making of the incentive payment by Alfredo, she'd need to be prepared to litigate and bear the financial burden and the risks inherent in that, including the possibility of an adverse costs order if the court's not prepared to accept her argument, and the evidence in relation to the incentive payment. As I've the conclusion I've arrived at in my paper is that she would not be successful trying to have Alfredo ordered to make that $35,000 payment. That covenant would not come across with the transfer of the land. It wouldn't come across and remain with the reversion. So because that $35,000 is actually more like an agreement that sits by the side of the lease, and it's probably more of a Walsh and Lonsdale kind of equitable interest. And of course you haven't got that privity of contract between Patricia and Alberto, and so if she wanted to recover the $35,000 from him, or then she would need to be able to do that by establishing that $35,000 covenant, that incentive payment covenant, was actually a part of the legal lease, and she can't do that. So she, her only option to try and get that $35,000 is to pursue Giuseppe, because she still has that privity of contract with Giuseppe. I might have said contract before when I meant equity, privity of equity. Estate, sorry. So she can pursue Giuseppe, and of course that's of no concern to Alfredo. So she still has that privity of contract with Giuseppe. She has the privity of estate with Alfredo. So if she wanted to enforce the making of the incentive payment by Alfredo, it wouldn't be met with much success. It's not something we would recommend based on her prospects of success, which are pretty much nil. During that whole time too, her business would suffer due to the expense and inconvenience of relocation, of litigation, and there may be no funds to be had from Patricia, even if Alfredo were to end up being successful litigating. So it's a similar factor for Alfredo. The costs of litigation are prohibitive in the circumstances, and pretty much a cost-benefit analysis would probably see him agree with that view, I'd say. If Alfredo wanted to enforce payment by Patricia of the outstanding rent and compensation for reletting and damages for repairs, he'd also need to litigate and bear the costs and risks associated. So during this time, he may suffer financial losses if Unit 1 remains untenanted, and he bears the risk of taking on an unknown tenant and the unpredictability of whether their business will succeed and allow them to remain as good tenants for the term of the lease. And of course, as we said before, there mightn't be any money left from Patricia. One point is that we don't have enough information to know whether or not the lease is a retail shop lease. If it is, obviously that's the best outcome for them both in terms of being able to arrive at a low-cost dispute resolution process. So they could go to mediation, and even if mediation didn't work, they can go to QCAT, represent themselves. No big expenses there. So while the retail shop leases legislation provides Patricia and Alfredo with a less costly and less time-consuming process for resolving the disputes about unpaid rent, damage and Jamil's nuisance, the issue of the $35,000 incentive payment can't be dealt with at mediation and QCAT because it doesn't form part of the legal lease. So it would still need to be enforced in a court of equity. Time-consuming, expensive. So the prospects: relief against forfeiture is likely to be granted. The fact is that the breaches are not serious in relative terms; they're rectifiable or compensable. So I can, from the authorities I've drawn together, I can see that there's not likely to be an order for forfeiture if the matter were to proceed to court. Patricia needs to be aware also that if Alfredo waives his right of re-entry or forfeiture, then she may need to pay his legal costs. His right of re-entry in relation to the breaches of the covenants. It's also interesting to note, finally, the duties of respect. The courts imposing duties which involve responsible dealing with one another in good faith, non-derogation from the grant. So it's probably fair to say that both parties are obliged to mediate, negotiate. So at the end, my offer from our client would be A, Patricia repair the damage and repay the rent within 1 month. Alfredo address issues with Jamil within 7 days. The parties commit to negotiating in relation to the incentive payment, the currently due incentive payment and any future incentive payment, and options for further 4 years. But that's all of that takes place only after 6 months of on-time rent payments. Obviously, Alfredo's going to want to see that, Patricia's making a show in good faith of her, attempts to be a good tenant before he starts committing to any incentive payments or any option for further 4 years. And no other compensation claims by Patricia for interference or derogation. That's a lot. Thank you very much. Thank you. Bye.